This week, a company in the Brisbane Magistrates Court was convicted and fined $1 million for claim farming, which is a practice where people receive unsolicited contact, harassment, duplicitous behaviour, basically in an attempt for them to make a personal injury claim. So the charge was laid by the Motor Accident Insurance Commission. The anti-claim farming laws, they do help us to avoid becoming an overly litigious society, but there are instances where people genuinely are injured, whether on the road or at work, and they need some support. Some don't seek that help for a range of reasons, including that old school value of wanting to grin and bear the injury or not wanting to jeopardise their job. To help you understand your rights when it comes to seeking compensation for being injured at work, I spoke to personal injury lawyer Shane Crew from Crew Legal. With many of us taking up casual work or joining the gig economy, I started by asking him whether casual workers are covered if they're injured doing their job.
As a casual worker you are, because you do fit within the definition of an employee. So under the work cover laws, the first step to look at is whether you're a worker under the Act, and a worker is defined as, in its simplistic form, an employee for PAYG tax purposes. So a true independent contractor is a different kettle of fish. They're not necessarily a worker, although just because you're called an independent contractor doesn't mean that you are.
Right. So what makes someone a genuine independent contractor or not really? What are the criteria to think about?
Yeah, so there have been a number of court decisions where they talk about the indicia of employment, which is things like control, supervision of your work, whether you're wearing a uniform with a logo, whether you're told where to be, when to be, whether you use your own tools or the tools of the company that you're working for. So a whole bunch of factors like that which have to be looked at.
Take us back into work cover. Can you give us a short summary definition of what work cover is and what it does for us?
Okay, so work cover is a compulsory scheme in Queensland for injured workers or employees. So essentially there are two types of work cover claims. The first one we call a statutory claim, which is a no-fault scheme, where if you meet three criteria, essentially if you're a worker, if you've suffered an injury, and if your work is a significant contributing factor to the injury, then you're entitled to benefits under the work cover laws. The second type of work cover claim is what we call a common law claim, where that is a fault-based claim. So in addition to having to establish those three factors, you also have to establish that your injury occurred as a result of negligence on the part of your employer. And that's a claim that comes second, and a claim that's for a lump sum amount of money rather than wages or medical bills and things like that.
Can the latter types of claim be much higher due to the negligence?
Yeah, so common law claims are for lump sum amounts of money, which include damages for not just what's happened to you so far, but for future loss of income, future needs for expenses and things like that. So a larger sum of money.
Okay, so work cover was set up to provide worker compensation. Are there any loopholes where people end up not being covered or protected in a way they thought they might be?
It probably comes down to that first issue of whether you're a worker. So when you go to work for an employer, historically at least, some employers in attempting to reduce their exposure to superannuation benefits or work cover premiums have required you to have your own ABN and invoice each week for the work that you do and be paid that way. And that opens up that danger of whether you're classified as an employee or you're classified as an independent contractor, and that's where you need advice on, well, where do you really sit? It's not just because you're called a contractor that you are, but rather do you meet those indicia of employment factors we talked about before.
And I feel like there's more ABN-style work emerging. More people are Uber driving and Uber Eatsing and all these gig economy type jobs are emerging. On that subject, are certain groups more at risk of not being covered? Those people, or perhaps new migrants to Australia taking on cash and hand work if they struggle to find full-time employment? Other groups that you're noticing that are a bit at risk of falling through the cracks?
So in terms of the gig economy, that's an interesting one. So a recent case involving essentially a freelance cameraman who will work for a number of different entities as they require. But on the particular job that he was at, he was really employed as a worker for that particular day. So he was using their cameras, told where to be and when to be, but still invoicing for his time at the end. And so it became a very interesting tension between, was he a worker, was he a contractor, was he entitled to work cover or not? So the gig economy is an interesting one. In terms of migrant workers doing cash and hand work, generally speaking, they will be workers. It's just the problem for those people is that they don't know what their entitlements are.
Right.
So they're not in tune with what the legislation in Australia or in Queensland entitles them to. So getting them the knowledge that they're entitled to make that claim is probably the bigger factor.
Do you think more work needs to be done there with migrant support groups? Or, as a lawyer, what would you suggest could be done to help those people?
I think programs to bring their rights and entitlements to their attention are going to be important. Equally, in Queensland, we have very strict advertising restrictions on lawyers who try to give that information out. There's currently a committee working within the government to determine whether those restrictions get spared back a bit or pared back a bit, and that'll be something for the next year ahead where hopefully we can start getting out that information unrestricted. That's
an interesting tension that you bring up, because you are restricted in how much you can communicate to not turn Australia into an overly litigious society, perhaps. But information does need to get out so people know their rights. Can you tell us about some of those restrictions? What are you not allowed to say as a lawyer?
Yeah, so we're not allowed to advertise the fact that we might do something on a no-win, no-fee basis. We're not allowed to attach that term to an advertisement for personal injury services. In terms of the services that we provide, we're only allowed to outline what those services are. We're not allowed to outline in any detail what they may involve,
okay.
And that's something that even on our websites has to fall behind an initial page for you to make a genuine inquiry in order to receive that.
You're listening to Shane Crew, who is a personal injury lawyer, talking to us about some of the issues around that subject. Is it true, Shane, that you're covered on the way to and from your place of work? And if so, are there any mitigating factors with that?
Yeah, so under our work cover laws, there's a type of claim called a journey claim, and that covers you if you're injured either in a motor vehicle accident or even walking to or from your place of employment. The only factor at play there is that you must be taking a direct path to or from your employment. If you deviate to a shop or deviate somewhere that's not within your ordinary path of travel.
Not even for a coffee?
Not even for a coffee. No?
Okay.
If you tripped over on the way into the coffee shop having deviated from the way to work, then that would negate your entitlement under the Work Cover Act.
Okay, so the journey cover just treats it as part of work. You're covered just as well as if you were at work. You're covered just as comprehensively as if you were at your workplace.
Certainly in that initial statutory claim. Obviously, your employer is not necessarily going to be liable in a common law claim for things that might happen to you on the way to work.
Right.
They don't control the environment that you're in whilst you're on your way there. So, but in terms of the statutory claim at the start for sort of wages or medical bills or rehabilitation, things like that, you're covered as if you're at work.
Lots of Australians get involved in voluntary work. If you are doing that type of work, are you protected, or do you have less protection than if you were part of paid employment?
You certainly have less protection. There's a couple of voluntary worker types identified in the work cover legislation, and they are sort of rural firefighters or honorary ambulance members and things like that. Otherwise, it's dependent upon whether the not-for-profit entity that you're volunteering with has purchased a work cover policy as to whether you'll be entitled to make a claim.
What would your advice be to someone who is injured at work? What's the journey like if they do decide to make a claim?
It doesn't have to be a stressful or complicated scenario. So what generally happens is that you suffer an injury at work, you'll go and see your GP or a hospital, and as long as they're aware that you've suffered that injury at work, they will complete for you a medical certificate that gets lodged directly with WorkCover on your behalf. And WorkCover will then contact you, check with the circumstances of how you're injured, and then offer to cover your treatment and rehabilitation expenses. And that's very easy, very simple process. It just becomes a bit more complicated when you start to get to the end of that rehabilitation and you have to start considering, well, am I receiving all of the entitlements that I might have? And do I have the opportunity to make that second type of work cover claim, being the common law claim? And that's generally when you might contact a solicitor and get some advice about what your rights might be.
It sounds like during the statutory claim process, it's all quite methodical, but in the common law process, you might engage a lawyer. Is that when you become at risk of racking up legal fees that you may have to pay if you lose the case? Can you tell us what your potential liability is in that situation?
Yeah, well, there are a set of what we call pre-court procedures that you're required to follow, which are risk-free for all intents and purposes. So if you engage a law firm and they're acting for you on a no-win, no-fee basis, you'll go through a process of making a claim, going to medical examinations, and then ultimately attending a compulsory settlement conference where your representatives and the representatives for WorkCover will see if a resolution can be reached without ever bothering the court system. It'll only be if a resolution can't be reached at that point that you then commence a court proceeding, and that's when any risk associated with legal costs or a costs order against you might begin. And that is if you ultimately proceed all the way to court and a judge decides that your employer was not negligent and that you don't succeed in your case, then you might be ordered to pay some legal costs for WorkCover having had to defend your claim.
Do you have a sense of how many people in Queensland, maybe not an exact number, but are just sitting there? They are entitled to deal with their injury, but they're stoic and they're just putting up with it, and the years and decades pass without them getting what they're entitled to.
I think that's a real problem insofar as we have time limits that apply to making these claims. So for the statutory claim, your time limit's only 6 months. So if you suffer an injury today and you wanted to lodge a WorkCover claim for benefits, if you haven't done that within 6 months of today, you lose your rights to do so. The common law claim is a period of 3 years. So if you sit back and say, well, I'll wait and see what happens with my injury, I'll see if it affects me, and 3 years go by, if you're knocked out of the workforce at that point but you haven't protected your rights, you've lost those rights. So I think a lot of people find themselves in that predicament where they realise about 5 years after the event that they can't work anymore, but by then it's too late.
Shane Crew is the Director of Crew Legal, personal injury lawyer. Shane, thank you for coming in and sharing your insights with us today.
Thank you for having me.